Excused.
Representative Chestick. Representative Haroldson. Representative Jennings. Representative Nemec. Representative Oakley.
Excused.
Representative Provenza.
Excused.
Representative Rodriguez Williams.
Here.
And Chairman Washut.
Here.
Thank you.
We have a quorum. We have several members busy in other committees on the Senate side, I believe, maybe some on the House side as well this morning. And so we will proceed. Just a few comments about how we operate here in House Judiciary. First off, welcome to the 67th annual session. Please turn off your cell phones. If you needed to make a call, please leave the meeting room. If you intend to propose a substantive or lengthy amendment to any of our bills this morning, we will need a written copy for each member of the committee, as well as 2 for our staff. If you need to have copies made, there's a copy center across the hall, and Miss Sandy Dent will help you. The meeting is being streamed live on the legislature's website. A link is located at the meeting calendar page. Those not wishing to testify online are encouraged to watch via the legislature's YouTube channel. Normally, we proceed in House Judiciary, taking first the bill sponsor and the sponsor's witnesses, and then other legislators who might wish to testify, state agency or court officials in the room that wish to testify or via Zoom, then representatives of interested organizations and members of the general public, both online and in the room. We ask that those testifying press the microphone button until the light turns from red to green. Say your name. And if you're new to this committee, please spell your last name for the record. Please speak clearly and speak up so the committee, those in the room, and those listening in our virtual audience can understand you and hear you. Then add the agency or organization that you represent if you do so. If you're here as a private citizen representing yourself, please tell us where in this great state you reside. Remember that all dialogue must be addressed through the chairman. Witnesses are expected to remain polite and civil during their testimony. Audience members online wishing to testify should register using the testify button provided on the committee's meeting notice. Please do so at this time. Those registering will be emailed the link to participate via Zoom platform. Handouts for the committee should be transmitted to each committee member. Audience members are encouraged to watch the proceedings via YouTube until their topic of interest is introduced. For those online, at the time that I call for public testimony on a topic, if you wish to testify, please raise your virtual hand and you will be called on as time allows. Staff will then modify the attendees' credentials, at which point they will need to have their video turned on, their microphone unmuted. Following testimony, staff will then modify the attendees' credentials as needed. Public testimonies should not last longer than 30 minutes unless extension is granted by the chairman. I will have access to see which attendees have raised their hands, and we'll do our best to kind of see who's up on deck to let people prepare. Once a virtual attendee has concluded testimony or does not anticipate providing further testimony, please monitor the proceedings via the YouTube channel so that others may join the meeting. We only have a limited number of spaces for people to be queued up to give testimony online. The bill or bills being discussed are located on the meeting calendar page on the legislature's website. So with that said, we return to House Bill 241, which we began on Wednesday but did not complete. Representative Yen, why don't you get us going this morning? Welcome.
Mr. Chairman, thank you. I'm Representative Yen. Members of the committee, I know that Representative Provenza had introduced the bill and you did take a little bit of public comment, so I won't dive into the text of the bill. I would love to talk about the intent of the bill and what the bill can help solve as a problem. This morning, Representative Provenza and I are switching committees, so she's in my committee and I'm in yours. So I'm very excited about that. I will say that when I was working on this bill, I actually had this drafted 2 years ago. So 2 years ago, I had realized that this was one of the states where there was a situation where officers who have people in custody could still have sex with them. And, you could believe that there could be a consensual relationship there, but even in that situation, you can still get decertified, but it still doesn't count as sexual assault. So the reason that I brought the bill is I truly do believe that if you have someone in your custody, you have power over them where they cannot essentially say no. So whether or not it could truly be consensual, it's impossible to know that. And so an officer should never have that situation where they put themselves in a place where they have sex in police custody, because and us as a state would never be able to know whether it is or is not consensual. So the standing should generally be, it cannot be consensual because you have that power over an individual who is in your custody. And so Congress actually worked on this in response to an article in 2018. So they had made it so their federal Department of Corrections could not have sex with inmates. And we've had that on the books for quite a while. But just this last year, they made it so all federal peace officers cannot have consensual sex in their custody because the consent cannot exist. And so I decided that this would be the year that I would bring it, even though I didn't bring it 2 years ago. I did some research and was able to find out that there are quite a few post-decertifications regarding inappropriate relationships with people in custody. And I think that alone means that it is a situation that does happen in Wyoming, and we just should have this on the books to make sure that it doesn't happen and that it shouldn't just be a decertification. It is non-consensual sex. And so that's why I bring you House Bill 241. Thank you, Mr. Chairman. I'm open for any questions.
Questions for Minority Floor Leader Yen. Representative Shusty.
Thank you, Mr. Chairman, and Representative Yin. Thank you for bringing the bill. I'm 100% in support of the intent of this. I plan to vote yes for it, but I'm concerned that there may be a loophole here that we need to close. And the loophole involves potentially circular definition. You use the term victim throughout this, which leads to the question, if the person in custody says, hey, I consented, therefore I'm not a victim. You have to go look for what does victim mean. It is defined in another section, but it's defined in reference to a criminal violation. So it gets kind of circular. So I'm wondering if the simplest fix here is to change the word victim, wherever it shows up here, change it to person. And that will get you out of that circular definition problem.
Mr. Chairman, I'm more than happy to support that amendment.
Thank you.
Other questions? Representative Harrelson.
Thank you, Mr. Chairman. So Representative Yin, thank you. It's an interesting conversation, obviously, and it's sad that this is even having to be a conversation, but it is. But on page 3, line 8 through 13, where it says evidence of marriage is defense, the fact that the actor and the victim are married to each other is not by itself a defense to a violation. So I'm going to play the what if game. And obviously I know this isn't out there what if, but what if there was a situation where a spouse was a guard at a prison or a law officer or something of that nature, and the individual that they arrested was in fact their spouse or was in that type of a position. Now, obviously they were married beforehand. Then at that point, it's something that's not a grounds for defense. I mean, I'm just trying to get my head wrapped around and maybe I'm completely off and not understanding, but I just want to make sure I understand that if someone were to be married before there were to be an infraction and then they were to be placed into this situation, which I would hope that we would never place someone into that situation, but if it were, that could still be something that could be pressed and that would not be a grounds for defense.
Representative Yen.
Mr. Chairman, thank you. I think it'd be a very interesting situation if your spouse arrested you, placed you into their custody, and then you guys, and then they had sex, right? So, and then marriage was used as a defense. So I think that is a situation that's very hard for me to imagine happening, but I suppose if it did happen, I would still say that if the officer used their peace officer powers granted to them by the state to put their spouse in custody, they should still not have sex in that situation.
Representative Yen. There's already language in statute that talks about sexual assault involving someone in a position of authority. Would you address why you think this is still necessary?
Mr. Chairman, thank you. It's because I don't think I've seen a case where it has fallen, that a case has been charged under a person of authority in that situation. So I want to make it crystal clear that it should not be the case that this happens. And we also have the Department of Corrections part in there as well, which already exists, to make it clear that Department of Corrections cannot have sex with their inmates. And so I think this is just another clarifying part where we make sure that all peace officers know that this is not a situation where it's appropriate.
Other questions for Representative Yen? Seeing none, can you stay with us for a little bit? Very good. I think we had Byron Oderkoven on the Zoom list. We bring him into the meeting, please, and Mr. Worrell. Good morning, Mr. Oderkoven.
Good morning, Mr. Chairman. Byron Oderkoven, the Executive Director of the Wyoming Association of Police. I can't quite decide if my camera's on or not this morning, sir.
You look a little gray.
Well, let's see if I can help that. I have a new computer to me and I thought I was good, but evidently not.
We can hear you fine. Like we can take audio testimony.
Very good. Thank you, sir. Again, Byron Oderkoven, the Executive Director of the Wyoming Association of Sheriffs and Chiefs of Police. Thank you for allowing me to come back around on the second day of testimony on House Bill 241. So I appreciate the comments from the bringer of the bill, as well as the presentation from Representative Provenza earlier this week. I would like to comment on a couple of points. And that is to reiterate again that 62303 sexual assault in the second degree, I believe when we worked on it and looking at the state statute annotations, it looks like it was last modified in 2018, that I think that describes and in statute what is contemplated by the bill before you. And let me refresh in terms of that discussion. So an actor who inflicts sexual intrusion on a victim commits sexual assault in the second degree if, and then we have 9 modifiers basically to that if. So, but the pertinent one for us is A, VII. So the actor is an employee, independent contractor, or volunteer of a state, county, city, or town, or privately operated adult or juvenile correction system, included but not limited to jails, penal institutions, detention centers, juvenile residential or rehabilitation facilities, adult correction facilities, secure treatment facilities, and the victim is known or should have been known by the actor to be a resident of the facility and under the supervision of a correctional system. So, Mr. Chairman, when we expanded that definition several years ago, we did, I believe, what this bill proposes, and that is we say that an officer cannot have sex with an inmate under any circumstances, and it's actually more broad in that we included several people above and beyond just an officer in that definition. I would remind you of AVI that says the actor is in a position of authority over the victim and uses that position of authority to cause the victim to submit. So again, I believe the circumstances described in the preparation for this bill are covered under the existing statute. Please do not interpret my comments as any way lessening the description of what is anticipated with this bill, merely an effort to point out that I believe it's adequately covered in statute and may not be necessary to address it in yet a new statute, Mr. Chairman.
Mr. Oderkoven, the statutes you just cited talk about jails and penal institutions. I'm curious about police cars out in the field, interrogation rooms inside a police station that may not be part of the jail and so forth, and also this question of consent, that if there was a consensual relationship and it took place in a police car or in an interrogation room outside of a jail facility, would statute cover that presently?
Mr. Chairman, rereading that, I believe when it says any facility, sorry, Mr. Chairman, I'm rereading it one more time, just Mr. Chairman, while it does not specify those other places you just described, I'm well aware of a case involving a patrol car that's been in the news of late, in which this was cited and the county attorney chose not to prosecute. So I guess that would probably be a question more for the county attorney as to why they chose not to prosecute, or as, for that matter, as the good bringer of the bill mentioned, there are several cases that have been before the post commission for decertification that were not prosecuted. And it would be interesting to hear from the county attorneys in those specific cases why they chose not to do a prosecution in those matters. So I don't think I have 100% clear answer for you.
Okay. Further questions for Mr. Oderkoven? Okay, please stand by and Mr. Worrell can bring Mr. Worrell in. He's in. Mr. Worrell, are you there?
I am. Thank you, Mr. Chairman. Can you hear me?
We can hear you, but
You can't see me? I have my video on.
well, Mr. Oderkoven looked gray, you look black.
I won't take that in any negative way. So
We can hear you, so go ahead and tell us what you'd like us to know about this bill.
thank you, Mr. Chairman, and I appreciate that. Also, Representative Yen Byron's got his on now, so I don't know what's going on. But I would suggest that, in fact, the section regarding in a position of authority and control is somewhat broader than the definition of custody, if you want to call it a definition that's contained in this particular statute. As drafted, at least this modification to the statute. I don't think anybody believes that it's a good idea for this to occur. But I think when you start defining custody, there's an entire body of law that's been developed over a long period of time, beginning with Miranda versus Escobedo, and also or Miranda and Escobedo, those two cases back in the 60s, which started defining custodial interrogations and things like that. Custody being the operative term. Are you free to come or go is a good way to look at that. But if a person is in a position of authority, and in this case that you were referring to, a law enforcement officer, detention officer, other person of that nature, that implies to some degree that they overcome any possible consent that would be there. Nonetheless, consent could remain an issue in certain circumstances. And I think it's better to stay that way, because to do otherwise sort of blurs the line as to when consent could be had and when consent could not. This particular statute, with a blurry line as far as what constitutes custody, makes that a strict liability offense. If it occurs in custody, it ranges from a felony that's up to 15 years, third-degree sexual assault, and a minimum 20 up to 50 if it's a second-degree sexual assault. And I believe when you have a blurry line, that's an awful lot of time to put on the person that's being accused. I think the statute as written adequately addresses the kind of conduct that Representative Yin and Representative Provenza and a number of others that brought this bill intended to prohibit, and I think appropriately so. And when you raised it, Mr. Chairman, I was thinking the same thing. The position of authority, I sort of like it because it focuses on the actor rather than the victim and the circumstances of the victim. If the use of, for example, a law enforcement officer could encounter somebody on the street and suggest to them, I can arrest you anytime I want and take you to jail. Maybe they think they're high on drugs or something. But instead, if you wish to perform this or that act, maybe that won't occur. I don't believe the statute as proposed would cover that scenario because no one's in custody yet. But that officer that made that proposition is certainly in a position of authority. So if anything, I believe the flexibility offered by the current provisions of the statute supports a greater degree of accountability on the part of law enforcement than with this amendment, with its somewhat muddy definition of what constitutes custody. Thank you.
Mr. Worrell, it does seem to me that this question of consent still remains. Is there a way we could address that satisfactorily in statute so that it makes it abundantly clear that any sexual relations between a person in custody of a peace officer or a correctional officer, that there's no way that can be consensual simply because of the power differential?
That's what the position of authority provision provides, Mr. Chair. In addition,
Mr. Worrell, though, it says that the position of a person in position of authority overcomes, right? And so,
right.
If there's nothing to be overcome because it's consensual, does that language work?
It does, because it requires the position of authority to overcome otherwise consent that's presumed. And it goes to, it is a broader phrase than to say, you got to be actually in some form of custody, having been arrested or detained, I believe is the terms. Under arrest, detained, or, and I've got it here, just a moment, I can look at it. Under arrest, being detained, or otherwise in the actual custody of law enforcement and the actor. My concern with this centers around the idea that that there are circumstances, and it's really hard to foresee, But there are circumstances where consent could be had up to a point. I like the idea that it requires the law enforcement officer to actually utilize the authority to overcome what might otherwise be considered to be consent, because there are people that have been arrested that are going to say, no, I consented to that. What's the problem? You know, I thought I might get a break here. And this particular statute is just, in a way, it's limiting, and I'm somewhat uncomfortable with the definition of custody contained in it, because again, that's a new definition, I suppose, in a manner of speaking. And it describes three different circumstances, but the last one is otherwise in the actual custody of law enforcement and the actor. Virtually every police officer that's ever walked the earth has made a DUI arrest in the field, depending on the time of day. And I'll tell you what I always told my kids: if they got stopped by the police, the first thing you do is say, am I under arrest? And if they don't get an answer to that, say, am I free to go? And if they aren't, then they're in custody. Is that what we want to do? Do we want to have that? And that's kind of the way you have to do this. There's a lot of different ways people overcome custody, or prove custody, and that's subject to interpretation. There's administrative interpretations in driver's license hearings. There's judicial determinations in suppression hearings. And those are based on a different standard of evidence than beyond a reasonable doubt. Yet, if that custody question is proven by any form of evidence, it would appear that under this statute, there would be strict liability for a substantial amount of prison time. I don't think anybody wants to say, and I certainly do not, nor does Mr. Odakoven, indicate to this body that we think in any way, shape, or form, sex with a person in under your control by law enforcement officers or a person similarly situated is acceptable. That's certainly not the point. The point is that we have a statute that addresses this in a somewhat broader way and possibly more effective way, because it still requires the consideration of consent. Other than, sorry, go ahead.
Any other questions for Mr. Worrell? Representative Oakley.
Thank you, Mr. Chair. Good morning, Mr. Worrell.
Good morning.
So, and I missed some of the discussion, my fault, but I just was wondering, so the two subsections that you're saying it could go under would be a person, the victim, by any means that would prevent resistance by a victim of ordinary resolution, which is usually sort of, I don't know, like talking about fighting somebody off, and then the actor's in a position of authority. But in position of authority, of course, you mentioned broader, but usually lands us in, I mean, there's a lot of case law about position of authority, and there's a reason. A lot of them have gone to appeal because it is broad. So I guess my question is, I mean, do you find it that odious, I guess, if you will, to have a specific subsection, so you're not trying to go to this, to something broader, to a position of authority or somebody, a victim of ordinary resolution? Anyway, just wondering what your thoughts on that are, Mr. Worrell.
Mr. Worrell.
Thank you, Mr. Chairman, Representative Oakley. My thoughts on that are that, to amplify your point, is there's a substantial body of law of what constitutes position of authority. And it also contemplates that that position is used to overcome consent. I don't think that's a bad thing here. When we're talking about somebody could make an allegation of sexual contact, and there might not be anything other than the old he said, or she said, or he said, she said, or she said, he said. to use all the pronouns, I think. We don't have that kind of contest. The proof would be the use of position of authority to overcome what someone might even say is consent. You could have cases you're prosecuting with unwilling victims, and that's okay. But my biggest concern with the way this particular modification of the statute is written is it creates strict liability where some form of overcoming of consent has always been required otherwise. And I think that's the way that should remain. And to once again address your point, there is a substantial body of law. Sometimes in an attempt to clarify things, we end up limiting them. And I just don't believe that would be appropriate. Thank you.
Further questions, Mr. Worrell? Mr. Worrell, are you aware of any cases where we didn't get a conviction at trial because of this consent defense where it involved a peace officer or a detention officer or a correctional officer with a inmate or person in custody?
Because what, Mr. Chair?
Where consent was the defense and we did not get a conviction.
You know, it would be really hard to gauge that because those kind of cases would not be reported ordinarily. They would be anecdotal because what defendant is going to appeal a case that was found where they got found not guilty? So I'm sure they exist. Don't get me wrong, but and there are two prosecutors sitting on your committee here, as well as a law professor who I have not seen before, but I've enjoyed listening to. They may be aware of some of these cases. I've been a prosecutor for 8 years. I am not aware of a case. There was reference earlier to a case that wasn't prosecuted that may or may not have involved a custodial arrangement, but that's kind of how I would address that. It is, I can't specifically say there's this reported case that says this. People that get acquitted don't usually appeal. Thank you.
Thank you very much. Any further questions, Mr. Worrell? Anyone else wishing to testify on 241? Anybody in the room? Anybody online? Representative Yen, you want to bring us home and then we'll close public comment?
Mr. Chairman, thank you. So the last bite of the apple that I would give the committee is that, you know, the case that brought national attention and the reason Congress closed it was a situation where the alleged assaulter claimed it was consensual and the victim claimed it was not consensual. And that was the situation where the case was not a conviction.
And just to be clear, that was a federal law enforcement officer?
Mr. Chairman, no, that was a New York state case and it did spur New York to change their laws. But it also, the article on the situation got national attention that gave Congress the impetus to change their law on it too.
So Representative Yen, if we were to somehow just take the language from lines 15 and 16 on page 3 and weave it into existing statute, would that get us to where we're going without redefining custody and these other terms?
Mr. Chairman, that may do the trick if it still falls under person of authority. I guess the prosecutor still has to pursue that it was the person of authority using their powers to cause the victim to submit, though.
Anything further?
No, thank you, Mr. Chairman.
Thank you for bringing the bill. Committee, close public comment. Any, what's the pleasure of the committee?
Move the bill.
Moved by Representative Shestak. Second by Representative Provenza. amendments, proposed amendments? Representative Chesky.
Yes, Mr. Chairman, to address the potential for circular definition, which I still think exists in line 15. I propose that wherever the word victim shows up in this bill, be replaced with the word person. And that, I think, solves the circular definition problem.
Is there a second? Second by Provenza. Debbie, are you clear on the amendment? Okay, correct. Discussion on the proposed amendment? Question being called on the amendment. All in favor, say aye.
Aye.
Opposed, no.
No.
The amendment has been adopted. Further amendments on 241? Representative Jennings?
Yeah, Mr. Chairman, I like where you went with 15 and 16, and it sure saves a lot of paper. If we strike the rest of that and leave 15 and 16 on page 3. I think that goes closer to what we're trying to do.
Is that a amendment?
And I'm not sure how you put that in there.
Nor
Maybe
am
one of the
I.
good country lawyer would help out here.
Representative Craig.
Thank you, Mr. Chairman. That is actually already existing law, so that won't really get us anywhere. That particular amendment would not solve the problem. We'd have to actually add language into subsection B under 62307 if we were going to try to do that. I mean, I've been thinking in my head conceptually, what would that look like? And I said, well, if it's the person is a peace officer and the provisions of, I think we could do that, the provisions of 62303A6 apply, and the person is a peace officer. That would take them out of the position of authority. That could not be used as a defense in that particular case because it's already, so if you notice, under 62303A7, Romanet 7, consent is not a defense if you're a peace officer and under that particular provision. So you're in the correctional system, you're subject to the rules or whatever of the correctional system. I can't remember the exact language. No, that's not, it says, sorry, under the supervision of the correctional system is what that part of the statute says. And so actually, I mean, I'm gonna have a hard time voting for the bill because of that, because I think it's already covered. But if we want to just shore that up and make sure that it's covered under Romanet 6, I think we could come up with some language right there and it would accomplish the same thing.
I'll just withdraw my.
Further amendments being proposed. Representative Craig.
Thank you, Mr. Chairman. So in an effort to try to move this along a little bit, so line 16, page 3. We would have to get rid of the Romanet 10 there because that will no longer exist if we do this amendment, but we would add the language 62303A little 7, which is already there, 62304A little I, which is already there, then put a comma and put or 62303A Romanet 6 when the actor is a peace officer. We have to use the right language when the actor is a peace officer, period. And then the rest of the amendment would be to strike, and there would be conforming amendments, but we'd have to strike everything on page 1, beginning with line 12, all the way through page 3, line 6.
Representative Craig. So if this language falls under 62307 with the evidence of marriage, does it matter where we have this language embedded here?
Thank you, Mr. Chairman. In theory, it could, but I mean, the titles within the statute books don't mean anything. I mean, we have we have a statute that actually says that. And so whatever the language on the page says, that's what it says. That's what it means. It really doesn't matter where it is in the green books. If we wanted to put this particular statute in the Department of Ag, it still would have, if we want to put it in Title 11, it'd still have the same meaning. So I think that's just where they put it the last time they did it. So no, the answer is it'll still work there.
Thank you. Is there a second to Representative Kragel's amendment? Or second by Haroldson? So let's state that amendment one more time and make sure Debbie's got it over here. So Representative Kragel.
Okay. Thank you, Mr. Chairman. Well, let's start at the beginning. Page 1, starting on line 12, strike all of the rest of remaining page 1, all of page 2, and page 3 through line 6. And then on page 3, line 16, we are going to delete the inserted language, which is the Romanet 10. And at the end of this sentence, we will remove the period, add a comma, and then put or 62303A Romanet 6 when the actor is a peace officer, period.
Debbie, do you have that?
Yes, I do.
Committee, everybody clear on what the amendment there? Any discussion on the amendment? Let's see, an urge to vote. All in favor of Representative Kragel's amendment, say aye. Oh,
So
Debbie?
on line 13, at the very end, the 10, do we want to remove that too?
you know, there's a reason we have a really great secretary in this committee, huh? Representative Kragel, do we need to get rid of the X at the end of line 13?
Yes, Mr. Chairman.
So we'll strike the or X and put the period after Romanet 7. Very good. All right, now we'll vote. All in favor of Representative Kragel's amendment, say aye. Aye. Those opposed, no. The amendment is carried. Any further amendments? Any further discussion on what's left of the bill?
Yeah.
Representative Kragel or Representative Jennings?
Just a question, Mr. Chairman. So I didn't catch that, but we deleted the X on line 16 also. Is that correct? Okay.
Yes. Any further discussion?
Real quick.
Representative Haroldson.
Thank you, Mr. Chairman. Just and of course, I'm just trying to get my head wrapped around. I'm still learning this whole process, but we struck out victim and added person. Is that going to then become, that one did pass? Are we now at a point where we're going to create kind of an abnormality in our statutes where it's not going to conform to the rest of statute? Because what I'm concerned about is the fact that we did that in pre-existing language, and the rest of the pre-existing language has the word victim and uses the word victim, but now in this one section, we're using the word person. And so what we're going to have to do is ask the question, is that a good policy choice? And I voted for that, but I'm just now thinking of that might not be the best answer.
Representative Kragel. So we have victim changed to person on line 10 and line 15. Is that problematic?
Yes, Mr. Chairman, which is why I voted against the amendment in the first place. But we can fix it, and we just change the word person back to victim on those two lines, line 10 and line 15 on page 3, because that's the only place it's left within the bill draft. And I would make that motion.
Is there a second? Seconded by Oakley. Discussion? Okay. Are we clear, Debbie, on that we're changing person on line 10 back to victim and changing person on line 15 back to victim? Discussion? Okay, all in favor of Representative Kragel's amendment, say aye. Aye. Those opposed? No.
Thank you.
That amendment carries. Further discussion? All right, let's have a roll call on what's left of 241.
Representative Craigle,
Aye.
Representative Chestick. Representative Harrelson. Representative Jennings. Representative Nemec,
Aye.
Representative Oakley,
No.
Representative Provenza,
Aye.
Representative Rodriguez Williams,
No.
Chairman Washit.
Aye.
We have a total of 7 ayes and 2 noes.
Committee, please quiet. Debbie, can you give me that number again?
We have a total of 7 ayes and 2 noes.
7 ayes, 2 noes. With that, House Bill 241 is amended. Passes House Judiciary Committee. Thank you, Representative Yen. Excuse me? That brings us to House Bill 248. We tag team with members of Health and Labor. Welcome, Chairman.
Thank you, Chairman Washit, members of the Judiciary Committee. It's good to see many of you again. Sorry, I'm not on the committee this term, but Labor Health is a heck of a good time next door. I bring, as I'm sure this committee is, I was watching some of you. Has this mic been difficult? Let's try that one. That work okay, Mr. Chairman? And I'll scoot a little bit to the right. So today I bring House Bill 248, Vital Records Amendments. And I would like to call this clarifying language. I'm not sure that's completely what you'll hear from people who are here to testify on this bill. But let me at least run you through the basics of vital records in the state of Wyoming, like all states, keeps track of our births, our deaths, our marriages, and our divorces. And so they are the official custodian, the State Department of Vital Records under our Department of Health. So it's the Division of Vital Records, who are responsible for collecting all this information for a wide variety of statistical purposes. So as we went through their statutes, there have been some concerns over some of our language when it comes to what is and what isn't required. So our State Department of Vital Records, Division of Vital Records, I hate to say contracts, but works with local designated officials in each of your counties, primarily your county clerk, your county coroner, to collect marriage records, divorce records, birth and death records. And so we've had some, I would say, concerns between attorneys at the state and the county level on exactly what certain terms mean. So what this bill does, I can walk you through it real quickly. First, you'll hear, so 35-1401 on page 2 is our vital record statutes. You'll hear about these, they're called books, right? And they're historic books, record books, and they contain data. And so the question before you, and I think you'll hear from both sides, is whether these books are rightfully, the information contained in them are the property of the state and the Department of Vital Records to use that information with all births and deaths and marriages in Wyoming, or whether they are kind of withheld to the county because they are, I hate to call them sacred historic artifacts of the county, but the county in some cases believes that the information contained does not need to be sent to the Department of Vital Records. So you'll hear about these books. And then on page 3, we're just clarifying what a local official, a medical coroner, and what reasonable time is. And so in our statutes, we just don't have definitions, and there have been some concerns over what these definitions are when it comes to the term, what is a local official? Someone who has been basically designated to be a record keeper, submitter on behalf of that county and what happens in that county, marriages, deaths. So we're primarily talking to county clerks and the county coroners when it comes to who are these local officials and the records they are required to provide to the state Division of Vital Records. And then we're just clarifying what a medical coroner is in our statutes. And then we are having to quantify what reasonable time is. And I think you'll hear some concerns from our Division of Vital Records that the statute says reasonable time to turn over these records, primarily death records, and what the regulations at our division are not necessarily being followed by our counties. And so we wanted to make sure in statute, when we say reasonable time to at least turn over and notify the department of a death, that means 72 hours. Then on page 4, historically in our statutes, the state registrar, which is our head of our vital records, should provide all of their county officials the postage to send in this information. Now in the electronic age, almost all of this information is digital. Some still is by postage. And so this isn't a make or break, but one of those nice things where most of these are electronic, to take the requirement for the state to give the counties postage for the vital records out of statute. But if you decide that's not your will, it's not going to hurt my feelings. Otherwise, then we're just clarifying what is the Division of Vital Records in the Department of Health. And then they're on page 5. We're talking about recorded marriage licenses in these books that aren't already contained, that aren't already included in our state Division of Vital Records, that they need to be, I guess, given over to Vital Records so Vital Records can handle the statistical information contained within them. So that's one of those conversations between attorneys on, do these books that contain records need to be turned over for the Division of Vital Records? I'd be happy to answer any questions, but I know there's a lot of people here wishing to testify. And if it's okay, Mr. Chairman, I do have a bill in another committee. So if I sneak out, not trying to be rude, just trying to defend multiple
Okay.
bills today.
Very quickly, any questions for Representative Zwanzer? Representative Jennings?
Thank you, Mr. Chairman. Representative Zwanitzer, on page 4 and going to page 5, I think you missed explaining that part. But as I read that, starting on line 20 or so, I don't have my glasses this morning, Representative. So if I miss this, where it's a certificate of death and marriage registered 1 year or more after the date of occurrence shall be marked delayed. Now, I don't know exactly why they did that. And shall, it's not permissive, it's shall show on their face the date of the delayed registration. But then the new language would say no delayed mark shall be shown on the face of any marriage filed and registered from those county books and records not already contained in the system. So it seems like there's a contradiction there. Could you explain that?
Representative Zwanzer?
Mr. Chairman, Representative Jennings, I would be much more excited to let the department explain delayed. I think that's kind of an artifact of statute in the old days when you had to securely mail these to the department, and they didn't get sent as timely as the department would like. And there were legal ramifications if the State Department of Vital Records didn't have this information contained. But I'd be happy to dodge that question to a member of the audience.
Representative Oakley?
Thank you, Mr. Chair. Representative Zwanitzer, I can't talk this morning. So I guess I'm looking at 2 of the definitions, the added definitions on page 3. In specific here, line 15 and line 19, I guess I'll just start. So 15, defining medical coroner means a county coroner or a deputy coroner elected. I'm just wondering, it seems strange to me because I think we have one coroner in the state that's a doctor. And so when we're trying to get somewhere, if we need to take out their medical instead of then turning around and defining that our coroners, it just seems to me if they're not medical, then defining it as such is bizarre. I'm trying to understand that. And then reasonable time, defining the word reasonable pops up in my head as by the reason we use it is to add that sort of discretionary thing to it. So if we want to say the time period which you have to get this done is 72 hours, then we just say that instead of trying to define reasonable time as 72 hours. It would make sense to me to take out reasonable time and say the time that they have to perform this is 72 hours. Anyway, those are my thoughts. If you have any.
Representative Zwanzer?
Yeah, Chairman Wash, Representative Oakley. So I guess there are 2 ways to handle the medical coroner issue, which is currently in statute. You could delete the word medical and then just say coroner. But I think we want to make sure, things have changed. And so now you have in many counties a coroner and you have multiple, I believe we have 5 deputy coroners in my community. And so they just wanted to make sure that was broad enough that coroner's on vacation or it's all an electronic system now in many cases. And so other people can input that information and they have passwords. And so that's on the coroner part. I believe they just wanted to make sure to include deputy coroners instead of coroner to clarify it. Reasonable time, I think you'll hear from the department. This is when notification of a death primarily. And so I think in my opinion, what's happening, some people are very good at saying a death happened and we're still, in some cases, investigating why and going through the process. And so some counties are turning that over. We're letting you know, and it's all an electronic system again. So they let you know the death has occurred, but they're still going through various aspects of cause of death, right? Other counties are saying we are going to complete the full, investigation, autopsy, what have you, before they turn in that information. So in some cases, someone could have been passed away for weeks before the State Department of Vital Records is notified. And so I think that's why the division is asking for a definition of reasonable time, whether that's 72 hours or a different number. I think that would be the hope in this computer system, that 3 days is enough time to know.
Very good. Well, let's let Chairman Zwanitzer return to his committee. And who do we have in the room? Any state agencies here to talk? State agencies? What's it? All right. Well, some new faces before Judiciary. So introduce yourself and who you represent and tell us what we need to know about 248.
Yes, Mr. Chairman, Guy Bedoin, Deputy State Registrar, Wyoming Department of Health Vital Statistics Services. Thank you for the opportunity to present before you. If I may, Mr. Chairman, answer a couple of questions. Representative Jennings had one to begin with, and then maybe going over to Representative Oakley as well. So the question, Representative Jennings, that you had with regards to delayed. There's a function with regards to when a document is filed with a local registrar. So we'll use the marriage as an example. A marriage license is issued by the county clerk. That party then would take that to an officiant who would conduct the ceremony. It would be solemnized. And then there's a period of time that document needs to be returned to the issuing clerk. So the statute says 10 days that the officiant needs to return that. Sometimes people forget. So that document may sit out a year, 2 years. It doesn't change the fact that it was solemnized and it's a legal marriage, but it hasn't been filed correctly. So those documents, if they're brought back later than a year after the event, would be filed delayed. And we would ask the party to provide evidence as to why it was late, and to maybe just that the event occurred and that they just didn't fill out the license. And I'm looking back at Mary just as a representative from the clerk, but did not take it back to the clerk. So that's a standard delay, and the law says, hey, anything older than a year needs to be presented and stamped as delayed. If that document was brought back to the county clerk and the county clerk records that return and puts it into a book, but doesn't send it to Vital Records. So the law also states that within a period of time, so it's like 10 days of 1 month, all the previous month's marriages are supposed to be sent to Vital Records. Let's say that it got skipped. And 5 years later, they say, oh, here is a marriage that we forgot to provide to you. When they send that to us, they've already ensured or confirmed that all of the legal requirements were met when they recorded it. So we won't record that as being delayed. We'll assign a state file number to it, put it into our files, and then issue that if it's requested. So if there were a number of historic books, as an example, that we don't have in our Vital Records system, we wouldn't want to go in and stamp all of those delayed because they were returned to the clerk in the time that the law required. So we would want to be able to accept those books, get them scanned, indexed, and put into our system, assigned a state file number, and then we could issue those documents. So I hope that, Mr. Chairman, Representative Jennings, I hope that clarifies the delayed.
Thank you for that answer. Just a quick question on these books. are we still using books today? Is that or are these things that are, 1800s type books, or are these, tell me a little bit more about what we're talking about with these historical books.
Mr. Chairman, in 2007, the state developed a system of vital records that incorporated marriages. They allowed the clerks to be able to use this electronic system. The clerks also use, it's called Document Pro. It's a company out of Montana that has Tyler Technologies. They have a marriage application that's associated with the titles and deeds that the clerks use, and it's an accounting tool as well for them. They developed an applet that basically exports marriages to the vital statistics application. So today, to your question, the books may be printed off, the license may be printed off and put in a book, but they're also recorded in an electronic media, which is acceptable for data storage and keep.
Representative Jennings?
Yeah, follow up, Mr. Chairman. So back to the delayed, it says shall not be shown on the face. Do you have to go back and remove that delayed stamp or something there?
Mr. Chairman, Representative Jennings. So I guess a scenario is the best way to describe this. So when the clerk receives it, if they received it in a timely manner, it would not be recorded. It would not be recorded as the clerk as delayed. It would only be recorded by the State Office of Vital Records if it was received 1 year after by the party and not by the clerk.
Okay. Further questions? Anything further you wish to tell us?
We did have then, with regards to marriages, Chairman Washut, or I don't, if we have any other questions, I'll go to Representative Oakley, if that's all right, and answer. You had a question with regards to the clarification of medical coroner. If I may, then, Mr. Chairman. So 35-1-418 is death registration. The law indicates that event needs to be filed within 3 days of its occurrence. So whomever assumes custody of the body has 3 days to file this. We have an electronic system for that as well. So a funeral home picks up a body from a hospital, they go back to the funeral home, they log into our system, they create a new record, then they select the medical certifier for that. Upon that notification that the medical certifier gets, they would then start working on the death registration. So in 418, if I go down to paragraph C, sentence 4 and 5, in sentence 5, it states that a non-medical coroner shall not diagnose the cause of death without consulting with a competent physician. Or in this particular case, I think what we might want to do is look at, for medical coroner is defined and use the reference for 35-22-402. So that healthcare practitioner, so an APRN, a PA, a doctor, or a DO. So if they are a
Could you get that
medical
statute
coroner,
number again one more time?
I apologize, Mr. Chairman. 35-22-402 A Romanet XIV.
XIV?
XIV, yes, sir.
Thank
So
you.
that-
Please continue.
That would provide us with who those healthcare practitioners are. So again, physician assistants, the medical doctors, DOs, they're all licensed under the Board of Medicine. And we have the executive director for the Board of Medicine here today. And then the Board of Nursing for advanced practice registered nurses. So if the coroner is not one of those parties, the requirement is for them to consult. If they don't consult, then we would like to know why. How can you diagnose a condition or a disease without having some type of medical experience?
Follow up, Representative Oakley.
Thank you, Mr. Chair. And is it Director?
Deputy
Deputy Director, sorry. Just trying to get the title.
Registrar. Yeah, thank you.
Deputy
Yeah.
Registrar, okay.
Yeah.
So I hear what you're saying and I appreciate it. And I don't want to put you in a spot, but I'm assuming this is coming to us because you've had some issues.
Mr. Chairman, Representative Oakley, yes. We do have, on our death certificates, we actually put a statement on there asking the coroners to provide who they consulted with. And I understand the manner of death. It's quite easy for a coroner to say, that's an accident. It was an automobile accident. The person died from blunt force trauma. But we don't know what caused maybe an event that led to the accident. So maybe they had arterial sclerotic cardiovascular disease. They ended up having, due to being clogged up, for lack of a better term, they had a stroke or a heart attack, which made them drive off the road and have an accident and succumb to the injuries. But what precipitated that? And as noted earlier, we do have one coroner in the state of Wyoming in Teton County as a medical doctor. And that individual would be able to provide that cause based on review of medical records without having to consult. But we do feel that everyone else should consult. And in that, I think it makes our data better. That's one of the elements that comes as an output from vital records, is we provide our birth and death data to epidemiologists who look at why are people dying? Why did people die? And we believe that would kind of clear that up, so we ensure that all non-medical coroners would actually consult.
From your point of view, is there anything in the bill that, other than what you've already mentioned, that would cause your office challenges to comply with this proposed statute?
Mr. Chairman, the medical coroner, adding that language in to define what a medical coroner is would provide assistance. And in where it states reasonable time, if you remove the word coroner and put medical certifier. So we're not just asking the coroners to do this, we're asking the doctors to do this too. So when a provider is given a notification that an individual dies, we believe that 72 hours from that notification is adequate. I did provide to the committee a couple of documents, some spreadsheets that have a lot of looks like old Spectrum numbers on it from some old equalizer or something. But basically, if you look at how long it takes for the death record to be filed, our average is about 2 days. So the funeral home, it takes them about 2 days to get it into the system. Coroners are in that same boat. What takes people a long time is getting that death certificate signed by the doctor. The coroners have the opportunity to file that death record pending. So let's say a coroner goes in and they're actually, they take custody of a body, they file that death with the state. If they think that the autopsy and that the any toxicology or any investigative measures after that are going to take longer than 10 days, they can file this document with us pending investigation. We'll record it. The family can actually request one of those documents to kind of use to clear up an estate. So you could potentially have that done. And I will use a coroner Mr. Chairman, in your county, the coroner uses a system called Coroner Case Management System. They get these done in 1 day. If they know that it's going to take a while, they file it pending, they get the death certificate produced, then the family can use that document to not necessarily get insurance. That usually requires cause and manner of death, but they're able to use that document then to shut off a cell phone or change an electric bill, as an example. But we think that 3 days, 72 hours is adequate. And again, that's from notification. So as an example, if you're notified as a practitioner, and then we determine that, through looking at the medical records, it's really this other doctor, we're going to send that death certificate electronically to another doctor to review and sign. From the time that practitioner gets that notification, they have 72 hours to complete that. So, Mr. Chairman, that's I've talked enough.
Very good. Thank you for coming this morning. Nice to meet you. Representative Oakley, one more.
Thank you, Mr. Chairman, Deputy Registrar. So I'm just still trying to figure out the best way to do this. So we define medical coroner, non-medical coroners in here. Am I just missing it? Where's medical coroner used? No, you probably don't have the
Mr. Chairman, Representative Oakley, medical coroner is not listed in there. Non-medical coroner is listed. So by providing a definition for what a medical coroner is, you should be able to clear up in, so 35-1-418, subparagraph C, you go down to sentence number 5, and you'd have to look in the green book for that.
Representative Oakley.
Thank you, Mr. Chairman. So I think we can figure out how to do this. I don't think defining a term in statute that doesn't exist anywhere else is the way to do that. But I will work on it because I appreciate the intent. I don't think this is how we get there personally, but thank you.
All right, thank you. Are you going to stay around just in case of further?
Yes, sir,
questions?
Mr. Chairman, I'll stay here and provide any clarification I can.
Thank you very much. Good morning. State your name and agency for the record and tell us what we need to know about 248.
Thank you, Mr. Chairman. My name is Kevin Bonner-Blust. I'm the Executive Director of the Board of Medicine, which as Assistant Registrar Bedoin noted, we regulate PAs and physicians, both MDs and DOs. So the vast majority of the people who will be signing the medical certifications. The only concern we have with this, and we've had several discussions with Vital Records about that as recently as December, is the idea of what reasonable time is, to Representative Oakley's concern. And really, it kind of rears its head when you look at the existing statute, which is 35-1-418. And it starts off by saying a death certificate shall be filed with the local registrar within 3 days after the death. And it is filed by the funeral director or other person who first assumes custody of the body. So let's take a Friday evening, 6 p.m. on a holiday weekend. Let's go Labor Day. And so that evening, or let's wait until tomorrow morning, Saturday morning, that's when the coroner or the funeral director is able to get there. And now already we're 1 day into that 3 days that they've got to report. So now they got 2 more days. So they need to report by the end of the day on Monday, Labor Day. But here's the other part, and here's where the reasonable language becomes very important to Representative Oakley's point. And that's 418 sub C says the medical certification shall be completed and signed within a reasonable time after death by the primary healthcare provider. Notice that when you're talking about first just doing the death certificate, that's a hard 3 days. But when the law was drafted, they said, wait a minute, no, we're going to reasonable time for the medical certification. So there was a really good reason for that, because if you now say reasonable time is 72 hours after the death, because that's what you have is a reasonable time after death to do the medical certificate. Now we have a 6 p.m. death on Friday. The funeral home director has until Monday to get their report in. And as the assistant registrar pointed out, that then triggers the notification, we need a medical certification. We're already at almost 72 hours right there. And so the medical certifier is starting off under the gun. Now, that might not sound like a big deal because failure to do it, if it's willful, if you make that point, it's $100 fine. We're 6 months in jail. So 6 months in jail because this all took place, that's not reasonable, I would argue to you. A suggestion would be to perhaps instead change a reasonable time to 5 business days or 10 calendar days or something like that, to make it workable, because otherwise that 72-hour clock starts running at the time of death, just as it does for the funeral home director or the person who takes custody of the body. So that's our main heartburn. And the other is if somebody has trouble complying with this, we've repeatedly offered to the Department of Vital Records that, if a physician is refusing to do these, we can have a conversation with them, and the license is a really big stick. And so if we need to, we've got the big stick we can get out. But
Representative Oakley.
Thank you, Mr. Chair. Thank you. So I guess my question, first of all, if you just tell us, so obviously you just explained, first in time, death certificate, medical certificate. But so in order to, and I hear what you're saying, but so if we're going to amend this, what I'd like to hear from you is what would make sense. If you could maybe elucidate the process. What is reasonable? What would you like to see?
Executive Director.
yes, Mr. Chairman, Representative Oakley, I have to believe there's a good reason for the 72 hours for reasonable time elsewhere within this statute. And so I wouldn't want to tinker with that. That'd be the easy place to do it and say 72 hours is, or instead of 72 hours, 5 business days or whatever. My suggestion would be, I think you can go into section 418C because you're already in this whole section, and maybe I'm mistaken. And instead of saying the medical certification shall be completed and signed within reasonable time, say within 5 business days after notification of the medical, the primary health provider or something like that. So modify that in 418C. So you're specifically addressing that need for the medical certification, but not putting them on that 72-hour clock. So that'd be my suggestion, Representative Oakley.
Representative Oakley, follow up.
Thank you, Mr. Chairman. So you would like to see, because like I say, one of the things that I'm seeing that you're saying isn't addressed is death certificate first, then this medical certificate. So medical certificate must be done 5 business days after receipt of the death certificate. How would that be?
Mr. Chairman, Representative Oakley, something like that probably needs a little fine tuning that would need to be worked out with Mr. Bedoin and Vital Records, but I think that would be it. So the clock doesn't start running until the physician or the nurse practitioner or the PA gets notice. Because a lot of times the physician won't be there. They won't know that first day that their patient died. That's the way it works. We have hospitalists taking care of patients in hospitals, all those things. So that would be, I think, an acceptable start. If we needed to fine tune it a little bit on the other side of the hall, we could do that.
Representative Oakley, you're clear where to put the 5 days, or
I am.
further questions for Executive Director? None. Thank you very much for coming this morning.
Thank you, Mr. Chairman. Thank you, committee.
We have hands. Odie. Bring. After Mr. Odie. Oh, you're together? Please come forward. And they're all three to kind of tag teaming us this morning. Very good. Bring them all in.
Good morning, Mr. Chairman and representatives. I'm Mary Langford and I represent the county clerks of the state of Wyoming. It's my honor to do that. And I am joined today by the Honorable Julie Freeze, the Fremont County Clerk, and the Honorable Colleen Renner and her first deputy, Hans Odie, in Park County. And we are here for the purpose of discussing vital records, marriage licenses, and marriage license books. So I want to hand off to Clerk Freeze.
Clerk Freeze.
Thank you, Mr. Chairman and members of the committee. I apologize that my video is broken and I'm waiting for IT to get back to fix it. So I apologize for that. We are talking about the marriage license, the old books. We're not talking about whether we're being late in getting our stuff in. I think we've got a good process getting our marriage licenses in. So I want to take you down a couple of roads of the clerk statutes of our job. So the first one I want to bring to your attention is 18.3.402 AVI. These are the county clerk's duties. The county clerk shall have custody and keep all books, records, deeds, maps, papers, and copies thereof deposited or kept in his office as required by law. That's the first thing I want to tell you. The second thing is every recorded document has to be microfilmed that we have. And so every single thing from the beginning of time for here that microfilm was available has been and probably gone backwards once microfilm was available. And that is all housed at the state archives. It is our choice if we have room to keep our documents in-house. And if we can't, then we've been taking them to the archives. Those are our choices as counties. Every recorded document in our office, the county clerk may make certified copies of those. And for years and years and years, I'm an archive myself. I've been here for almost 45 years as the county clerk, not as county clerk, but in the county clerk's office. And for years and years and years, we did the marriage licenses, the certified copies, and all of a sudden it came to a halt that we couldn't do those anymore. We couldn't make certified copies of our records. And suddenly you had to go to state archives to get copies of these records. And then suddenly, all of a sudden, our books were being not requested, but kind of forcefully asked of us to send to the state. And a number of us have said, no, these are the county records and we're not going to do it. If you go to the marriage license statute 20-1-103B, upon receipt of an application, the county clerk shall ascertain by the testimony of a competent witness and the applicant the names, the social security numbers of the parties who have social security numbers, residences and ages of the party, and whether there is a legal impediment to the parties entering into the marriage contract according to the laws of the state of their residence. The clerk shall enter the facts ascertained in a book kept by him for that purpose, except for the social security numbers, which shall be provided to the state office of vital records and not made part of the county public record. I also want to say that I have gone out to the rules for the vital records, and after 50 years, our marriage licenses are public. I have records here in my office, the books that we're talking about from 1887 to 1988. So some of those are not yet public record, but a majority of them are. So the books that Fremont County has is again under the rules where now they could be public record. I also went to the Vital Records website and I see on there that marriage and divorce records are on file from May 1941 to the present. So apparently you can get a certified copy of those from the state. And then it tells you that the records that are over 50 years old may be obtained from the Wyoming State Archives, where we all have to put our microfilm. I have digitized, I'm doing the final one with some of the ARPA money that we got, thousands. I mean, we are probably going to, when we're done with this project, over all the time that I've digitized records is almost $1 million to digitize the records. But that doesn't mean that our permanent books aren't the ones that you want to keep, because if for some reason some digitization misses a page or whatever, I can go back to the books and I can say, this is actually what is there. I am not willing to give up any of the county's public records that are in my custody. So I do have digitized records. I guess if the state wants them, we've been told at a meeting that they just aren't good enough. I tend to think that I haven't spent $1 million of taxpayers' money to do a bad job of that. But if they would like to have those, certainly we could get those passed on to them. Quite a few people do come in here because those records that are 50 years old or older, genealogy, or just general interest. One of my former county clerks, Jim Farthing, gave me a great lesson on the history and how to take care of records. And I take that with me. I take that very seriously. And I have a lot of extra records that he had, that like cemetery records. And I'm not willing to do anything different with those, because those are Fremont County's history that should stay here. If we aren't successful in getting that part of this bill out, where we don't have to give our books up, again, I said I have digitized those and I'm willing to give that up. And worst case scenario, on your last page 5, I will have an amendment where they will pay to get my books and I want them back. So with that, I stand for questions.
So Clerk Freeze, your basic testimony is there's not really a problem. We don't have to change statute.
I don't see any reason they have to.
Thank you very much.
Thank you.
Odie, do you have some testimony for us?
Thank you, Mr. Chairman. Yes, I do. Chairman Washut, thank you so much for the opportunity to testify remotely today. It sure is nice to not have to trek all the way down to Park County, although I'd love to see all your smiling faces. But my name is Hans Odie. I'm the Deputy Park County Clerk here in Cody. Mr. Chairman, I'd like to testify today that this bill feels punitive in nature to the hurried time frame that it was filed, which was back on the 24th of January. And it was not discussed with the clerks, who are the historic custodians of these marriage books. Mr. Chairman, back on December 21st of 2022, Deputy Registrar Bedoin and our Park County clerk, along with our Park County attorney, Brian Skorick, had an email conversation about who in fact is the custodian of these marriage records, marriage books, to be more specific. And Mr. Bedoin believes that he is, and his department is the custodian, and we differ in that. I will quote to you from an email from December 21st from Mr. Bedoin. If you feel this is incorrect, I'm going to ask you to continue to support the request, but ask you to get with your county attorney to request a declaratory judgment. However, we are still going to collect all of these books. Mr. Chairman, our county attorney turned around and said right away, please bring your declaratory judgment, and if it's in your favor, we will politely turn over these records to your department. Clerks feel that we've been cut out of this process, and Mr. Bedoin has gone through the legislative route rather than through having a conversation with the courts like he said he would. Clerks understand that we don't always get to be on the upfront development of legislation. That is not what we're saying here at all. But this really does feel like an end around for the Clerks Association. So with that, Mr. Chairman, I would stand for questions.
Questions for Mr. Rhodey? Seeing none, thank you for your testimony today.
Thank you, Mr. Chairman.
Back to you. Anything further from the clerks?
Mr. Chairman, I'm happy to stand for any questions, but I have nothing else.
Okay, questions? Seeing none, very good.
Thank you.
Anyone else in the room wishing to testify on House Bill 248? Seeing none, anybody else in the Zoom world? Committee, what's your, we'll close public comment. Committee, what's your pleasure on House Bill 248? Seeing no motion, the bill will be laid back. No action will be taken. In the interest of time and being the magnanimous chairman that I am, I'm going to push back my bill. House Bill 262, for those in the room waiting to testify on 262, we'll wait till next year. And that will take us to House Bill 101. Representative Craigo.
Thank you, Mr. Chairman, fellow committee members, Barry Craigo, House District 40. I'm bringing to you today House Bill 101 Uniform Trust Code Amendments. In the interest of time, I'm actually just going to get my key witnesses up here to testify on what the bill actually does rather than double dip. So if we could do that, Mr. Chairman, that'd be great.
That's fine. Witness, anyone in particular you're waiting for, Mr. Craigo? Come on down. Please introduce yourself and spell your last name for us and tell us what we need to know about 101.
Mr. Chairman, my name is Tom Long, L-O-N-G. And I am an attorney here in Cheyenne with the firm of Long, Reimer, Weiniger, LLP. And I'm here on behalf of myself and my law firm. And I am here to speak in favor of the bill. There are two other speakers that you should hear from today, Stephanie Milam and Marty Oblasser, and they will be appearing online. I am here to speak about two special provisions in this bill of most interest to my firm and my clients. And in particular, I want to speak about the amendments to sections. So the trust code is 4-10. So I may skip the 4-10 part, but I want to talk about sections 105 and 718 and also 813. I will start with 105 and 718. And I'm sorry, I don't have a copy of the bill in front of me now I do, Mr. Chairman. I want to speak about line 21 of page 3, which is an amendment to section 105B Romanet 13, which makes an exception to the rule that otherwise requires trust protectors and trust advisors to be mandatorily deemed to be fiduciaries. And then the companion to that exception, which makes specific reference to 4-10-718, is 4-10-718, which begins at line 20 on page 7. So those two I would like to address first. The amendment to 105B13 came in at the last general session, and it was intended to solve a problem of making sure there is a fiduciary somewhere in a trust. And the concern was that trustees are relieved of their fiduciary duties if there is a trust protector or a trust advisor who can direct the trustee to do certain things, make distributions, make particular investments. And so the statute we adopted back in 2003 says, well, when that happens, then the trustee really doesn't have to have fiduciary liability. The trustee is being told what to do by a trust protector or a trust advisor. So 2 years ago, a change was made to basically say the protector and the advisor doing things like that have to be fiduciaries, and there's no opting out of that within the provisions of the trust code that specify what's mandatory. This was made mandatory. The proposed amendment to 105B13 and to 718 to add a new sub G is intended to allow freedom of choice as to who is going to be the fiduciary in those situations. And it's, I will tell you, maybe I should make the bigger point that this provision has an economic impact on my clients, and I should, well, I will explain that as part of my testimony, but let me begin with the freedom of choice is what is being proposed here, so that a choice can be made. Either the trustee will be the fiduciary or the trust protector, but or trust advisor. Somebody will be a fiduciary. So the problem that was being attempted to be solved 2 years ago will remain solved. What this will do is bring back a little freedom as to who the settlor may choose to impose the fiduciary duty on. Now, here's why that matters, beyond freedom of choice should matter, but there are two types of trust arrangements that we have created many times for many clients, and this has created a problem. The one type I will mention first is what in the estate planning community is called a wing trust, WING, Wyoming Irrevocable Non-Grantor, WING, Wyoming Irrevocable Non-Grantor Trust. The key to solving the problem today is the non-grantor part of that. For income tax purposes, many people want to move their wealth to Wyoming. And that's a good thing. That supports administrative services, landlords, lawyers, I confess. And it's good for my staff as a result. The need for the trust to be a non-grantor trust is critical to the ability of non-Wyoming citizens to move their money to Wyoming and have it only be subject to Wyoming state income tax, which means zero tax. They like our state income tax bracket. And and to do that, the key ingredient to a non-grantor trust that is nevertheless for the benefit of the person who created it is that there must be another beneficiary or somebody that is described in the tax code. Section 672A of the Internal Revenue Code describes the need to have an adverse person who will also have some say as to how distributions are made by the non-grantor trust. The statute passed 2 years ago inadvertently put a fiduciary duty on the person who has to be adverse for income tax purposes. Yet under Wyoming law, if this is not changed, they have to put the other beneficiary's interest above their own. For the tax definition, they have to be somebody who is self-interested and doesn't put the beneficiary's interest above their own. So that is a real problem that is going to cause states like South Dakota. And by the way, we have an amendment here modeled after South Dakota's language in this particular provision, or Nevada or Alaska, or the states we tend to compete with to be a situs of trusts. We will be forfeiting this kind of trust. And the other risk we have, the second problem this creates is for trusts that aren't non-grantor trusts. They simply move to Wyoming from a state like California or New York. And the people that still want to live in California and New York would at least like to be trust protectors or trust advisors. But if Wyoming makes them fiduciaries, the California Franchise Tax Board, for example, thinks that if a fiduciary resides in the state of California, they're entitled to tax the income of that trust, even though nothing else is in California. We'd rather not fight that fight, but we've had enough fights that one of my partners in our Jackson office has now taken the California bar and is licensed to practice in California. I don't want to have to do that myself. And I would strongly encourage you to help solve this problem by restoring the freedom of choice. So that is one I wanted to talk about. The other is 813, which is on page 8, beginning at line 9. And I'm sorry, I'll try to make it quick here. We're short on time. This will, so what happened 2 years ago was we reversed course from 2003. When this bill was passed in 2003, it only applied to new trusts, and old trusts could opt in. And we have lots of clients with old trusts who did not opt in, and for various reasons. We have had many trusts move into Wyoming that are older trusts, and many of those have not opted in, and they nevertheless moved to Wyoming because they like our tax brackets. They like our uni-trust legislation. They like our prudent investor rule. It's not all about tax. It's all about our good laws. But in any event, what the change made 2 years ago was now you don't opt in, you're in, and you can't necessarily opt out. And that has created a particular problem with accountings. So section 813 is the duty to inform and report. And it says you have to do an accounting every year, and it has to be fiduciary accounting standards. You have to allocate income and expense as between principal and income. And that's not the same as tax accounting, it's trust accounting. So it's a second set of books. And a lot of our trusts don't do that. Trusts that don't differentiate between income and principal, that are fully discretionary, it's meaningless to have to do that, other than it's expensive. And so we want to restore the ability to opt out of that, rather than being stuck retroactively having all trusts, old and new, now have to comply with that provision. And with that, Mr. Chairman, I'm open for questions. Otherwise, I want the other speakers to have their chance.
Committee questions? Representative Justic.
Thank you, Mr. Chairman. And Mr. Long, when I was in practice, I was a trial lawyer, so I tried to stay away from estates and trusts. And whenever I had a client who needed a estate and trust, I knew who the good estate and trust lawyers were, and I referred them to them. I'd be referring people to you, I think, if I were practicing in Wyoming right now. But I'm confused. I don't really understand some of the concepts you were talking about. The one that really has me scratching my head is the idea of a the non-grantor trust. I don't even know what that is. But specifically, why is there a requirement for an adverse party to be part of the, he's one of the trustees, is it adverse party? What's the reason for that?
Mr. Long.
Mr. Chairman, Representative Chestic, a short course in what would be at least a week of.
I'm sure.
A non-grantor trust is a trust that is a separate taxpayer. It has to pay its own tax on its own income. And that's important to people who don't live in Wyoming, because if it's a grantor trust, then they pay the tax. And if they live in California, that's not a good thing. And so they want the trust, which is located in Wyoming, to pay its own tax. So it's critical that you comply with the non-grantor tax rules. One of the non-grantor tax rules is so the rules are in section 671 through 679. In 672A, it defines an adverse person as somebody who's also a beneficiary. And in 674, I believe it says if you create an irrevocable trust for yourself, and then you have the ability, without the consent of an adverse person, to get something out of it, even if it's an independent person, a Wyoming trustee, a bank in Wyoming, if it can give it to you without an adverse person saying that's okay, then it becomes a grantor trust again. And then the last piece of that puzzle is our trust code, section 718A, says if you have the ability to consent to a distribution, you are a trust protector, and therefore you are a fiduciary, and therefore for state law purposes, you have to put the other person's interest above your own, even though for tax purposes, you have to put your interest above the other person. So it's a conundrum. Okay.
Representative Chestic, is it clear now?
I actually got part of that. So I can sort of see the problem now, I think. So thank you.
Committee, it's 9:45. We have a hard deadline to be on the floor in the House chambers by 10. So other witnesses wishing to testify on this bill? Somebody on Zoom, we have Stephanie Milan, is that right?
Milo.
Mylan? Good morning. State your name for the record and tell us what you want us to know about 101 and try to be as brief as possible.
Good morning. Thank you, Mr. Chairman. My name is Marty Oblasser, Oblasser, and I'm an attorney over in Laramie, Wyoming with Fort Sill and King, and I will be as brief as possible. I am going to just propose that we make the amendments to 410-103, which is the definition section, to include that a power of appointment holder should not be deemed a fiduciary unless otherwise stated in the trust instrument. This is necessary because this is how people usually hold power of appointments. And as Mr. Tom Long had an opportunity to describe, when we start imposing fiduciary duties on people who should not have one in the trust, then we might be in situations that create legal liability or taxable issues. The next amendment we're proposing is to 4-10-103. This is simply cleaning up the trust code to ensure that other trusts that are created that are not considered qualified spendthrift trust, that's a specific type of trust, can still have a qualified trustee under this statute. So we're simply removing the qualified spendthrift provision and qualified trust property provision to still allow those trusts to fall under the 410-103A provision. And lastly, that I'm going to speak about before I pass it over to my colleague, Stephanie Milam, is about 4-10-302. It is a criticism of the Wyoming Trust Code that our definition here is limited to a general testamentary power of appointment, because there are other types of power of appointments that exist in the trust code and in trust instruments. So we just want to broaden the definition to be able to include all of those. I know I've been pretty quick on this, but if you have any questions, I'm happy to answer them.
So in general, are you in favor of House Bill 101?
Absolutely. It keeps us in the top tier of the states, and that's where Wyoming wants to be with our trust code.
Ms. Milam, do you have testimony?
Yes, thank you. I am also here in support of House Bill 101, and I will speak on the change to 411. The minor change to this provision is just to clear up unnecessary repetitive language. The more important change to this section is to make it consistent with other sections of the trust code covering the modification or termination of a trust by involving the settlor of a trust. Moving to 412, this section is being modified to make it consistent with 411 to provide that a non-charitable trust can be modified with the consent of the trustee and the qualified beneficiaries. This also, G is being added to protect a trustee from liability for relying or for consenting in good faith to a modification. 506, this section G is being added to cover certain types of irrevocable trusts that have become popular due to the increased federal exemption for estate tax and the probable reduction of that exemption in 2026. It provides that these trusts will have continued creditor protection after the death of the settlor or the original beneficiary, depending on the type of trust. This was also based on a critique of our trust code compared to other top trust jurisdictions. For 704, old trusts don't allow the settlor, if alive, to appoint a replacement trustee because it used to cause estate inclusion issues. The IRS issued a revenue ruling clarifying that this was not the case. So this change allows the settlor to appoint a replacement trustee rather than the qualified beneficiaries who could be adverse to the settlor. Any questions?
Any questions for Ms. Milam? Yeah. Unfortunately, a little bit of your testimony may have escaped us, but thank you.
Yes.
Anyone else in the room wishing to testify on 101? Welcome back to Judiciary. Introduce
Mr.
yourself.
Chairman.
State your name for the record.
Members of the committee, I'm Scott Meyer on behalf of the Wyoming Bankers Association. we have been monitoring this proposed legislation. At this time, there are some amendments that we think need to be in there, so we neither stand in support nor oppose this bill.
Thank you. Anyone else in the room wishing to testify? Anybody else on Zoom land? I want to close public testimony, take it back to the sponsor or bring us home.
Thank you, Mr. Chairman, committee members. What we're trying to do is make sure that our estate planning lawyers in this state have the ability to continue to do the job they've been doing. As you heard, we need to fix a few things that we messed up ourselves. And so we need to do that, number one, and then number two, continue to keep them on the cutting edge, essentially, in estate planning law. We're a situs for trust from all over the country, and that's a good thing. And I want us to continue to be that. So I'd ask for your aye vote.
Committee, your preference? Moved by Oakley, second by Nemec. Discussion or any amendments proposed? Any discussion on the bill? Representative Chestic.
Yeah. Thank you, Mr. Chairman. I understand some of this, not all of it, but I do want to keep this process moving. I don't want to kill the bill here. I think I want to keep it going, so I'm going to be voting aye on this. So, and then as the Bankers Association said, there may be some amendments that we can take a look at if we get that far on the committee as a whole. So I will support this bill and look forward to any potential amendments if anybody has any that they can explain to us. Thank you.
So when the law professor doesn't understand it all, the rest of us are doing our best.
Mr. Chairman,
Representative Jennings.
could we get a transcript of this in English?
We can wish. All right, we're about out of time. Do I have a motion? There is a motion. Okay. Question being called. Debbie, you want to call the roll, please?
Representative Cragel.
Aye.
Representative Chestic.
Aye.
Representative Harrelson. Representative Jennings. Representative Nemec.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
No.
Representative Rodriguez Williams. Chairman Washut.
Aye.
It's a total of 8 ayes and 1 no.
Thank you very much. Representative Provenza, did you want a point of personal privilege?
Like to have this conversation off after the meeting adjourns, if that's okay with you, Mr.
Very good. House Judiciary will be adjourned. I want to add that today's the last day for bills to come through, House bills to come through committees. So any bills that have not been heard in this committee, including my own, as we end this meeting today, will be done for the session. So that's where we're at. So thank you very much.